Ready, start. The contesting respondent had allegedly filed a revision challenging the impleadment order, which remained pending and was ultimately dismissed, directing the parties to appear before the settlement officer consolidation. Full stop. A transfer application was also moved by the petitioners before the Consolidation Commissioner, and the appeal was ultimately decided on 30/8/2010, setting aside the order of the Consolidation Officer and remanding the matter back to him and for decision afresh. Full stop. It is this order which was assailed by way of two revisions, and the same have been dismissed by order dated 31/1/2011 immune herein. Full stop. Learned counsel for the petitioners vehemently submitted that there was no ground for settlement officer consolidation to have condoned the delay in filing of the appeal, inasmuch as the notification under section 52 of the Act had taken place on 23rd March 1991, and there was no occasion for entertaining the appeal in relation to such an objection after such a long time. Full stop. He further contends that the alleged compromise was a valid compromise, and it had also been signed by the respondent number 5. Full stop. In such a situation, this aspect has completely escaped, which was essential, as the respondent number 5 had full knowledge of the proceedings as well as the sale deeds in favor of the petitioners, but no steps were taken for seeking any declaration in relation to the sale deeds of the petitioners before the appropriate forum. Full stop. He further contends that the name of the petitioners had already been entered into revenue records under the orders of the Tehsildar, which have not been challenged, and therefore the petitioners have acquired a legal right over the land in dispute, which cannot now be reopened by the consolidation officer on the basis of the remand order. Full stop. He therefore submits that the orders of the Deputy Director of Consolidations as well as the Settlement Officer Consolidation deserve to be set aside. Full stop. Shri Rajneesh Rai further contends that the revision has been dismissed, treating the order of the Settlement Officer Consolidation to be not final between the parties as an interlocutory order, which is also an erroneous approach in law, and so far as the aforesaid observation of the Deputy Director of the Consolidation is concerned, the order of the Settlement Officer Consolidation is not an interlocutory order. Full stop. It is evident that there was no substantial delay on the part of the contesting respondents, inasmuch as the order which was sought to be set aside in appeal was dated 19/8/1997. Full stop. In such a situation, the settlement officer consolidation was perfectly justified in condoning the delay and entertaining the appeal. Full stop. On the merits of the claim, it is evident that a compromise was being made, the basis for the order dated 19/8/1997. Full stop. The respondent number 3 admittedly was not a party to the said compromise, even if his natural father has signed the same. Full stop. The respondent number 3 was not claiming his rights through his natural father, but on account of the share being the alleged adopted son. Full stop. Learned senior counsel for the contesting respondent therefore is right while making his submission that the consolidation officer, while proceeding to dispose of the matter, ought to have taken notes of all the prospective heirs of the deceased Srimati Sona Devi, and therefore the consolidation officer fell in error by not issuing any notice to the respondent number 3 before having proceeded to accept the alleged compromise and decide the objections full stop. The other contentions of Shri Sirohi has also to be accepted inasmuch as on the point of delay the order itself was passed by the consolidation officer on 19/8/1997, long after the denotification full stop. The issue raised by the learned counsel for the petitioner that the matter has been decided much after the denotification in 1991 has therefore no substance full stop.